Good morning, good afternoon, good evening, everyone. We're delighted that you can join the Global Health Security Agenda Legal Preparedness Action Package as we undertake the first of a two-part series on liability and risk management in the field of legal preparedness. We've convened global experts, national experts who have been on the forefront of this effort over the course of the COVID-19 pandemic. We are confident that it will remain a critical factor of legal preparedness, as we're already seeing in the context of monkeypox, where we have an approved vaccine. The same kinds of issues reemerge with respect to procurement. We've roughly divided this webinar series into two parts. The first part will address sort of problems and challenges in legal preparedness and liability and risk management in the therapeutics and vaccine procurement process. The second segment, which will air exactly this time next week, will address solutions that emerged over the course of the COVID-19 pandemic, and some that are still developing. And again, we'll convene a community of global experts. My name is Sam Hallaby. I'm one of the leads of the Global Health Security Agenda Preparedness Action Package, along with the Office of Global Affairs at the U.S. Department of Health and Human Services and the Ministry of Health of Argentina. And it's a delight to be able to welcome them on this call as well. I want to say a couple of initial thank yous, especially to Cynthia Sun and Kat Ginsbaugh at the O'Neill Institute for National Global Health Law, both of whom you've heard from probably over the course of the last 3 weeks or so. We have a very full agenda. Hopefully all of you have had a chance to read through it. And so I don't want to spend any more time than this, just welcoming everybody to this really important conversation. I'm going to introduce our first speaker, Anthony Brown. Anthony is one of the global leaders in this space. He has years of expertise in legal preparedness and liability and risk management in the vaccine procurement process. And he is going to provide us a broad overview of what's at stake, how to define terms, and then what's to follow. Anthony, I'm going to turn it over to you.
Thank you, Sam, for that very kind introduction. Good morning, good afternoon, and good evening, everyone. I'm pleased to be here with all of you speaking about legal preparedness and in particular liability. What is it and why it matters? So let's just dive right into it. I like to start with definitions, very simple definitions, to make sure we're all using the same terminology and understanding the same language. So liability, a party is liable when they are held legally responsible for something. In the instances that we're talking about, the something is injuries caused by a medical countermeasure, normally a recently approved medical countermeasure. A liable party will likely be required to pay monetary damages. This is a bit different from criminal law, where a party that's found guilty would be expected to go to jail. The equivalent in civil law is to pay monetary damages. The amount of liability may be determined by reference to a statute or some other law or regulation, or may be decided on a case-by-case basis, just depending on the jurisdiction. And I'll talk a little bit more about why this is complicating the issue, in particular for manufacturers. And another area that complicates the issue for manufacturers is that the exact conduct necessary to be liable varies based on a jurisdiction's, that's to say a country, a state, a city's individual set of laws. The issue of liability arises with medical countermeasures when individuals who have been exposed to such medical countermeasures believe they have suffered an injury. This is particularly true with the use of vaccines, since vaccines are administered to healthy adults. An individual or an individual's family that has serious adverse event in temporal proximity to a medical countermeasure, such as a vaccine, may have been or believe they have been injured by the medical countermeasure. The health issues suffered by the individual may be completely unrelated to the vaccine or other countermeasure, or the result of a rare complication. Nonetheless, individuals bring claims against one or more of the companies or individuals involved in the development, production, distribution, or administration of the vaccine or other countermeasure. Generally speaking, when vaccines are put into circulation under normal circumstances, that's to say, not during a global pandemic of a novel virus, the manufacturer is liable for claims made against it, and in many cases agrees to indemnify other actors involved in making the vaccine or other medical countermeasure available to the public. For example, that could be the procurement agent, or that could be the government. That could even be a hospital, or a nurse or other health professional that is administering the vaccine. What's very different during a pandemic setting is all of that goes out the window, and manufacturers no longer accept being responsible to pay for litigating in any allegations of injuries caused by whatever the medical countermeasure is. Generally speaking, this is because medical countermeasures are rolled out over years. Vaccines are rolled out over years, and often they're rolled out within limited jurisdictions. As an example, in 2011, Kenya became the first country to roll out the pneumococcal vaccine. This was years, many years after the vaccine. Kenya became the first country in Africa to roll out the pneumococcal vaccine. And this was years after the vaccine had been rolled out in the US. So what we see is, under normal circumstances, the relatively limited number of doses and the limited geographical scope of rollout of a medical countermeasure allows manufacturers to basically gain information. They're able to understand better the exact safety profile and to model out and make estimates as to the number of serious adverse events, allegations that they may have to face over the course of providing the vaccine to the public, or whatever the medical countermeasure is. And they're able to do this because they've been able to take years and a bit of time to understand exactly what the safety profile is. But however, during a global pandemic of a novel virus such as COVID-19, novel vaccines are developed and put into circulation at breakneck speed. For example, by September of this year, Pfizer-BioNTech had shipped more than 3.7 billion COVID-19 vaccines to 180 countries. That's less than 2 full years after emergency use authorization. That is truly unprecedented. And the distribution of a novel vaccine had never happened to that extent before. Just the sheer scale of the program at such an accelerated timeline presents sort of risk for the manufacturers that are unique to a pandemic setting. Other factors that introduce risk include the unparalleled level of scrutiny of medical countermeasures, which is in part due to rising skepticism of vaccination programs and public health bodies in general. And finally, just many people will likely experience health issues that coincide with the administration of a vaccine or a prophylactic. simply due to the massive number of doses being administered, whether the health issues are caused by the vaccine or not, particularly if we think about the recent case with COVID. Most of the early vaccines were administered in nursing homes where individuals were already experiencing health issues. So it can be sometimes attractive for certain parts of the population to take things out of context and imply that there are issues where there may not be any. And this introduces a high level of risk to the manufacturer. Claims brought against the manufacturer for harm caused by medical countermeasure are generally personal injury claims. And in nearly all jurisdictions, a manufacturer would not be liable for injuries caused by a properly manufactured and labeled vaccine, for example. In other words, normal personal injury litigation requires proof that someone is at fault, that they did something wrong. For example, there's a defect in the product. Someone was negligent or someone behaved with willful misconduct. Laws in each country and within countries differ greatly, with some countries requiring an injured person to prove defect and damage and a causal link between the two, and other countries also requiring defect, damage, causal link, plus a showing of negligent conduct. Each country has its own permutation and its own definitions as to what constitutes a defect, causation, and defines negligence differently. Cases turning on product defect and our negligence are often messy, unpredictable, and maybe open to judicial interpretation. And all of this uncertainty in the law and the interpretation of the law is problematic for manufacturers being asked to deliver millions of novel vaccines, millions of novel medicines across many different countries at the same time. Simply faced with this uncertainty, manufacturers who are holding all the cards, or maybe better said, holding all the vaccines, literally, will not take this risk. And they argue that they cannot, as the consequences could be financially catastrophic, as they are trying to litigate across various jurisdictions and in the various ways that the jurisdictions have articulated their product liability laws. All of these companies are publicly held companies, and of course they're beholden to their shareholders. Countries with laws in place that address manufacturer concern are, quite frankly, able to negotiate and procure vaccines and medicines at a much faster pace than countries without laws. As an example, countries that have a no-fault compensation system in place to provide compensation for injured individuals, or alternatively, a well-funded healthcare system that has universal health coverage. Also countries that provide immunity to manufacturers so that liability claims cannot be brought against them along with the no-fault compensation program to allow for the compensation. Countries that have immunity, no-fault compensation, are able to fast track to a certain extent their negotiations with manufacturers and not having to negotiate liability, certainly not to the same level that countries without those tools have to. Without limiting liability through immunity, manufacturers require countries to indemnify them for all costs associated with injury claims. And indemnification is simply when one party agrees to compensate another party for losses that the party has incurred or will incur as related to specified incident. But to be able to enter into these indemnity contracts or contracts that have indemnity clauses, governments must be legally able to do so. What prohibited or stalled many countries from entering into contracts is the fact that countries have laws. A number of countries, quite a number of countries had laws in place that prevented them from entering into broad indemnity agreements. They had laws in place that imposed restrictions on the government's ability to enter into a contract that included an unknown financial obligation, such as an indemnity that doesn't have any limits. Countries also have laws that prohibit the government's ability to execute an indemnity agreement that does not include an exception. For example, in the case of negligence by the manufacturer or negligence by some other party making the vaccine available. Of course, this was unacceptable to manufacturers who, in a number of cases, had lawyers on the ground in countries going through the legislation, going through the rules, going through court cases to see what had happened in the past, trying to understand what limitations countries had to being able to cover the liability that manufacturers thought that they might be facing. So some countries have been able to overcome these crises, for example, by the government seeking parliamentary approval or adopting specific decrees, legislation, approving regulations. This was all done in the midst of the pandemic. And obviously this created some real barriers for countries being able to procure vaccines as fast as other countries. And we saw this play out in real time as we were living through the pandemic. We saw countries that had laws in place, making it easier to address the liability issue. These countries were able to procure vaccines, as an example, early on, and countries that had to negotiate liability issues in real time over, in some cases, many, many months, were not able to enter into these contracts and had to wait essentially until the first deliveries of vaccines were made available to those countries that were able to procure quickly, and those countries that were not able to do so. What we also saw was a divide in a number of countries that didn't have the legal capacity to be able to address these issues in the same way that let's say richer countries were able to do so, either by throwing a large number of lawyers at the problem, being able to dive into the issues through other networks, academics, and pulling others from the country into the conversation. While in some countries, just the capacity of either the ministry or whichever the Ministry of Health or whichever department was involved in the procurement was quite limited. So this was a real problem, and addressing liability, trying to understand what liability is and the ways that we address it is something that we'll be talking about during the rest of today, and also in the next session when we do a deeper dive into sort of immunity and what that means, and also the no-fault compensation programs that were also set up. So I'll stop there and hand it back over to you, Sam.
Thanks so much, Anthony, for that very effective overview and ending on a really good segue to sort of regulatory capacity. So I'd like to welcome Liz Soto from the US FDA to address sort of regulatory factors on the liability and risk management question. So over to you, Liz.
Thank you. Thank you, Anthony. You really set this up very well because the regulatory factors also play a really significant role in the liability risk management framework with regard to medical countermeasures and all the medical products needed to address public health emergencies. This is because the risk-benefit decisions about the utility of a medical product are foundational to those decisions that are being made with regard to the liability that the stakeholders are thinking about. The regulatory status of a medical product often becomes a defining criteria for the procurement and the liability protection. That's because the regulatory status is a statement about experts' assessment of the product's risks and benefits, including what they know about a product quality. And it really sets up the real and perceived risks associated with a product. It defines the willingness for all stakeholders, the manufacturers, as Anthony was talking about, to sell the product, for the US, other governments to donate the product, for distribution, procurement, administration, which you'll hear about with regard to healthcare workers, and actual use of the product. So for medical products, similarly, as we were hearing and Anthony was explaining, for medical products that are used routinely, there are two types of products that typically will be thought about with regard to insurance coverage. Products that are commercially marketed under approval mechanisms, such as licensed vaccines, and for which the World Health Organization, if applicable, would have pre-qualification processes in place. That statement of approval is a reflection of the confidence about the relative benefits of a product with known risks. Similarly, for investigational products studied in regulated clinical trials, insurance policies reflect the unknown risks, but there's a balance between the need for human subject protections and product innovation. But for public health emergencies, the medical needs arise when there are there are no medical products available, as we saw with the COVID-19 response, or few candidates that may be promising to inject into the emergency, but because of the immediacy of the circumstances, often clinical trials are not feasible. And it becomes challenging to know whether, without the clinical trials in place, whether the product is helping the situation, harming the situation, or offering no benefit at all. Having an infrastructure in place to do the rapid clinical trials would be what's really necessary and ideal, but often that's not possible in the emergency circumstances. So we repeatedly find during public health emergencies that all stakeholders, the developers, the manufacturers, the procuring agencies, healthcare providers, patients, seek regulatory clarity about the risks and benefits, not only to inform the medical decisions, but as you were hearing, also to inform liability risk management decisions. Often access to the products become delayed trying to rely on the traditional frameworks, trying to put in place clinical trial infrastructure. So emergency access frameworks, the regulatory frameworks for the medical products are needed typically for the following types of products: the new novel products such as we saw at the beginning of the COVID-19 medical pandemic. Repurposed products also create challenges. So it may be a product that is approved for one type of disease or condition, such as, let's say, smallpox, but repurposed to use for a different indication or disease, such as monkeypox. Antimicrobials often fall into this space. And finally, as Anthony was referring to as well, there are products for which they may be approved for the indication, but there's very little clinical data and very little of their use in clinical, in humans. They may have been developed without human data, based on any human data, on animal data. At the beginning of the 2009 H1N1 pandemic, this was a very big challenge with regard to the vaccine that was regulatorily approved in a lot of places, but there was very little clinical experience with the product. So I'm going to discuss a little bit about what the US emergency mechanisms have emerged, just because that's my personal experience. There are two main emergency use mechanisms applicable to all the types of products, regardless of the regulatory status. One is expanded access protocols under investigational applications. That way, it's within the traditional regulatory framework for clinical trials, even though we are not using them under a clinical trial, they're providing emergency access. But that affords regulatory oversight with preservation of informed consent and IRB approvals. Second main mechanism that we use is emergency use authorizations, or EUAs. And they became much more known during the COVID-19 response, with FDA issuing literally hundreds of them. That is outside of the clinical trial investigational frameworks. And in that case, the regulatory agency must comply with criteria that must be in place, do a risk-benefit assessment, and there are required and mandatory and also discretionary conditions that are placed upon that authorization that are very important to consider. How much data is available, whether there will be an impact on the ability to conduct clinical trials, and all the operational issues, such as whether the manufacturer or government has the product, all play a really important role in the decision as to which mechanism the FDA will pursue when authorizing or making accessible a product under an expanded access protocol. So countries without these types of emergency use mechanisms have confronted barriers, and we saw a lot of this within COVID-19, and setting up a little bit of the challenges that you heard about as well in the liability with the procurement aspects of this. If you didn't have an emergency use access mechanisms, the similar delays in inability to procure it created problems in procuring the products. To help address these, the result in some of these inequities, the World Health Organization established its emergency use listing procedure for assessing and listing unlicensed vaccines, therapeutics, and in vitro diagnostics, all types of products. The EUL decisions and documents then can serve as a reference for countries' own regulatory decisions. And during the COVID pandemic, many countries enacted legislation providing for the emergency access to medical countermeasures, often relying on the World Health Organization's EUL or approval or authorization from a stringent regulatory authority. Some countries still perform their own regulatory independent assessments. And so how well these mechanisms worked and whether their support flexible and fit for purpose for future emergencies is really an interesting question that really is part of the next step in preparedness for pandemics. So the second part of this webinar, we will detail explanations more, as Anthony set up, about the product, about the relationship to immunity and compensation under the PrEP Act, which make regulatory status about the medical product a defining criteria. All of the mechanisms, frameworks that you'll hear about will rely upon that regulatory status. This makes it imperative to take into consideration the regulatory framework for providing appropriate emergency access when considering these issues in liability risk management. So thank you very much.
Thanks so much, Liz. We'll now turn to Dick Wilder. Dick is a senior scholar at the O'Neill Institute. He's also the former general counsel for CEPI, although I should probably clarify, as will he. He does not speak for either of those organizations specifically. But over the course of the pandemic, Dick was one of the global leaders in this space. So we'll look forward to hearing his perspective on what he saw and what he thinks the challenges and problems are. Over to you, Dick.
Yeah, thank you very much, Sam, and thanks to Anthony and Elizabeth before me, who covered a lot of the territory actually that I'm going to be covering as well here. I'm planning on doing things a little bit different in terms of what I focus on and sort of how deep I go on some of these issues. One of the things that's important to recognize is, I think, a point that Anthony made and made very well, is that there is a fundamental difference between how one deals with these issues of potential liability and indemnification when you're in a pandemic situation versus a so-called normal situation. When a pandemic arises, which is a very rare event, and certainly the COVID-19 pandemic was one that I think caught many people by surprise, you do have to move very quickly in order to do several things. One is to develop the interventions, whether they be vaccines, drugs, diagnostics, or others, in order to address the virus, to push back on the pandemic. The other is, as you're doing that, as you're moving rapidly, you do have to address, the normal issues, if you will, that come up in any process of developing a medical intervention, getting it into the market, and getting it out to the people that need it. And that, includes, as Elizabeth was explaining, the regulatory matters. And as she indicated, there have been over the years mechanisms that have been put in place by regulatory authorities to enable the products to be more rapidly approved, for use in addressing a pandemic or addressing an epidemic or things that arise quickly. The problem that we had when we were first responding to COVID-19 was that all of those mechanisms were there, or I should say partially there, but in some countries, but not all. And there's been some reference made to the fact that some low and middle income countries, didn't have in place mechanisms to address issues related to liability, and also, more fundamentally, I think, in terms of securing the necessary regulatory approvals to ensure that products can be brought into the market, as well as mechanisms for gaining access to those products and their distribution and utilization. And so when COVID-19 struck, I was working at CEPI at the time as general counsel, and we, like the rest of the world, were seeing what was unfolding. And this was in January of 2020. And we're looking at what was unfolding, and people in CEPI and others that had been dealing with these issues for a long time realized actually quite early on that this was going to be a significant global event, a significant global health event, and moved rapidly to begin the development of vaccines. In our case, for CEPI, develop vaccines against COVID-19, including, I think, the first deal that we struck for the development of the vaccine was done on January 23rd of that year, to begin the process of developing vaccines that then rapidly, sped up and developing more more candidates for the development of vaccines. But at the same time, it was recognized that there was not a global mechanism, that would enable any successes that were achieved by CEPI to be fully realized, in the sense that there wasn't yet a mechanism for addressing the need for funding for global distribution. There wasn't a mechanism yet for addressing a number of legal issues, the regulatory ones that Elizabeth went over, as well as the issues that we're talking about in this program, having to do with indemnification and liability. And so, we rapidly, got together as part of what was called the ACT-A, the ACT Accelerator, and the COVAX mechanism for vaccines, to develop an approach, whereby it would be possible for the vaccines to be manufactured and distributed on a global basis, both with respect to funding and some of these other issues that I mentioned. What was immediately apparent, at the time, was that the companies that were being called upon and were coming, into the development of vaccines were concerned about the potential for liability. As Anthony indicated, the potential for liability because these vaccines were being developed very rapidly. In some cases, for the mRNA vaccines, for example, were being developed on a platform that had not yet produced any product to come into the market anywhere in the world. And so, there was a lack of understanding of what the risk profile was at the time and would be once these products were produced and brought into the market. So against that uncertainty, the companies, were looking for some way to address the potential liability. And in some countries, the US and Europe and others, there were mechanisms that would address it through, as Anthony alluded to, a mechanism whereby there was some partial immunity, certainly not against, gross negligence or things like that, but there was some limitations on liability at the national level, coupled with a mechanism to finance the payment for injuries that might be suffered because of the utilization of a vaccine. So, again, there was, pre-existing mechanisms in some countries to address the potential for liability, and at the same time, to address those events that could happen if someone were injured by a vaccine. So a compensation mechanism for individuals that suffer from injuries. Now, there were many at the time, that said, well, this is just a burden that the companies are going to have to bear. To the extent that there's a potential risk for liability, then they should go out and get insurance, or they should self-insure. That is, just simply take the risk onto themselves and deal with it. They're the ones that are developing the vaccines, they're manufacturing them, they're distributing, they're selling, so they should be the ones to take, that risk. The problem is that twofold, I think. One is that, again, there was a fair amount of uncertainty about the risk profile, and, not able to get private insurance, not able to fully price out what the self-insurance might be. The second is, as I indicated, in a number of countries, there were mechanisms in place to provide for limitations on liability and a compensation mechanism in the event that someone's injured. So in a sense, that was, if not a standard, at least it was some guidance that companies were pointing to say, we need to have something like that to enable us to go forward. So there was a need then, to understand those mechanisms, to very quickly come to a political determination as to what the allocation of risk would be between companies and countries and governments, and come up with mechanisms to address that. And I believe, and I'm looking at you, Sam, but I believe that we'll get into the details of what those mechanisms are in the next session, next week of this program. But suffice it to say that, we were dealing in that context with the recognition that in order for this work to go forward of developing vaccines and seeing to it that they are distributed on a global basis, that those issues needed to be addressed. And I think early on we perceived that it would not be sufficient to just simply tell the companies that they have to deal with it on their own. And so this global coalition that included the World Health Organization, CEPI, Gavi, and UNICEF as the procurement agent, and PAHO as well, came together to come up with some, to first of all, gain an appreciation, an understanding of what the problems were and to address it. I should say on that score, there was something else that was quite apparent early on, and that is for a large number of countries. And here talking about at the time what was called the AMC 92 countries, that is the countries that would receive some financial support from or through Gavi for the procurement of vaccines, the AMC 92 countries, is that they were the ones that largely, and not exclusively, but largely had not thought through these issues and dealt with them in the past when it comes to this liability issue and the compensation issue for people that were injured. And so a lot of them had not done so before. And a lot of countries, at the national level, the government representatives from health ministries and justice ministries and the like, were raising some concerns, even red flags about, what's going on here? What are we expected to do? Again, isn't this something that's the responsibility of the companies to deal with? And so there was a need, to work through a lot of those, issues that are more at the political economy level than they are at sort of the practical, contracting level. But it was apparent from those discussions that in order to make progress rapidly, that there would be a need for those countries to have some legal support, to understand the full implications of what the problems are, what the issues were, and what the possible solution sets were to those issues. And so that was another problem that had to be addressed, and had to be addressed as early on as possible, to be sure that as we're working through these issues of the development of vaccines, they're getting the funding together for the procurement, the mechanisms for the distribution, and both across borders and at the international level, that there would be a need for all of the countries involved in this process, including the AMC 92 countries, to be sure that they had the right, in essence, legal infrastructure, or what I call the legal plumbing of all of this, to make sure that it worked in the way that was intended to work. Now, the last thing, let me just take a look at my notes here real quickly. But I was going to say that the last thing, perhaps, that I would say is that we had a fairly short period of time within which to think all this through, put together the mechanisms to explore these issues, and to have the discussions with industry and with governments and so forth. And so there was a need, in a sense, to invent early on this method of international collaboration. And one aspect that was stood up, and I think if we're looking prospectively in terms of how these kinds of issues relating to epidemics and pandemics will be dealt with in future, we stood up at the time, as I mentioned before, the ACT Accelerator for developing a broad range of tools against COVID-19, and the COVAX mechanism for vaccines. Now, that was not itself a legal entity, but the legal entities involved, including CEPI, Gavi, and the WHO, were the ones that had to take the legal responsibility for moving forward on these issues. And so that presented some problems as well. And I'm not suggesting that there's a need to stand up yet another institution in the public health sector. I'm just saying that for going forward, I think one needs to revisit some of the issues that arose in terms of putting together the global political and legal infrastructure in order to address these issues. Here we're addressing the issues of potential liability and how to compensate in the event of injury. But there were a host of other things, including, as Elizabeth indicated, the regulatory issues that needed to be addressed as well. We will, in the next session, talk about what was actually specifically done to address, these issues and concerns. But I would say that, one of the things that is an ongoing one, and I suppose one of the reasons why there's this ongoing negotiation on the pandemic treaty is the institutional piece. And here's the global institutional piece of how one, can comprehensively come to understand, very quickly what needs to be done and ensuring, that the right infrastructure is put in place in order to accomplish it. Sam, let me stop there and hand it back to you to move on to this program. But obviously, we're all standing by ready to answer any questions at the end. Thank you.
Thank you so much, Dick. So we've had a really great overview and then sort of a specific conversation about the regulatory aspects of liability and risk management, and Dick's perspective on sort of what procurement looked like for the AMC 92 and others. An important piece of this puzzle is also the financing piece. So our next speaker will address sort of how those factors inform decisions by international or multilateral lenders, which was reflective, at least in part, of national decisions as well. So I'll turn it over to Sharmila.
Thanks, Sam, and good morning, good afternoon, good evening to everybody. I'm Sharmila Ramasamy. I am a senior counsel here at the World Bank in Washington, D.C. I am a capital markets lawyer by training. I work on innovative financing as well as supporting our lower income countries through the International Development Association, or IDA, here at the World Bank. So as part of both of those portfolios, I had the opportunity of working on some of the World Bank's COVID-19 response. And that's the lens that I'm bringing to today's webinar, the lens of the financier of vaccine purchases. Now, it's interesting to sort of think about liability and risk management more generally, but in the context of the multilateral space where a lot of us as financiers were supporting low-income countries to actually finance their vaccine purchases. There is a lot of discussion of whether or not financing would be the block, the real sort of bottleneck in accessing vaccines. But as we will see, actually, liability and indemnification issues as well acted as a barrier to entry for low-income countries. So this is a very small slot for a very big topic, so it might be a rather condensed discussion. Happy to take questions and answers in the chat box or after, or even offline if anyone's interested. So just to sort of set the scene, I'm going to cover three main topics. Firstly, I know a lot of the participants and speakers before me have covered the general sort of landscape of liability risk management really well. I will try to sort of do a little bit of a refresher just to set it in the context of multilateral financing. Secondly, I will give a little bit of an observation and some of the experiences of the World Bank during the COVID-19 pandemic, trying to finance some of our countries and supporting our low-income countries in government purchases of COVID-19 vaccine. And lastly, since this is actually the action package for legal preparedness, I'd like to sort of think about what we should be thinking about next in the context of legal preparedness. All right, so let's start with setting the scene. I think everyone ahead of me has already sort of talked about how unprecedented the pandemic was, and it was unprecedented for a number of reasons. But for the context that we're speaking about today on liability risk management, really the critical piece that was unprecedented was the speed and the scale in which COVID-19 vaccines actually hit our arms, right? The speed at which they were researched, they were developed, they were manufactured, they were deployed. All of this really sort of truncated the timeline for vaccine production generally. And that coupled with the fact that you had a global rollout of the vaccines, meaning increased demand multiple than you would typically have, but very sort of limited supply, created a perfect storm. And this perfect storm really sort of impacted the balance of power in risk allocation, in liability, risk management more generally. Now, we've heard, of course, that risks appear throughout the vaccine process: delivery, distribution, administration, even after administration. And no one mechanism can really eliminate risk entirely for purchasers or for vaccine manufacturers. So there's a number of instruments in the toolbox, contractual provisions, domestic legislation, financial backstops. We've heard about a lot of this from the earlier speakers. But again, even with all of these toolbox and a landscape that was already very much developed in terms of how the balance of risks was allocated as between purchasers and vaccine manufacturers, the unprecedented nature of the pandemic, the perfect storm that it created, just meant that the ecosystem was disrupted completely, such that you have a balance of power that is now skewed towards manufacturers. So you have countries negotiating on the back foot almost immediately, because there's more demand than there is supply, and there's also a need for greater protection from the manufacturers and in terms of liability and risk. So what we were facing in terms of the contractual provisions, the legislative provisions that were necessary, they were all skewed more towards manufacturers. So with this setting, let's take a look next at the World Bank's role during the pandemic and some of our experiences, as well as what we experienced with countries sort of in lockstep as we were supporting them throughout the pandemic. Of course, just by way of background, the World Bank, through its multiple institutions, we're helping developing countries can strengthen their pandemic response, increase disease surveillance, improve public health interventions. Unprecedented is a word that we use a lot in the context of the pandemic, but the response as well from the World Bank was unprecedented. We're looking at about $204 billion in financial support alone from across all of the institutions of the World Bank at the height of the pandemic. And this involved, of course, dedicated COVID-19 fast-track facilities, but also trying to repurpose and restructure and redeploy and reallocate existing resources. It was a very sort of intense period for everybody, I know, but for financiers, we were really sort of trying to make the best use of what little financing was available in the shortest span of time as possible, so that financing was not a barrier to entry for vaccine access. Now, in the context of liability risk management, involving multilaterals has an added sort of advantage in that there's a little bit more of knowledge sharing in terms of risk allocation and liability risk management generally. International best practices that the bank could support, for instance. The World Bank itself was actually sort of providing assistance, technical assistance and training and knowledge sharing more generally, together with Sam and team and O'Neill, in fact, and others, to try and sort of help build a little bit more capacity at the country level of how to handle some of these various toolkits, whether it's contractual provisions or domestic legislation, and trying to sort of understand what others were doing in the landscape at the time. Also, through our bank facility procurement, there's more sort of hands-on approach in terms of engaging and assisting with procurement and reviewing arrangements with manufacturers. Most of the time, though, what we did sort of see was arrangements that are already sort of agreed to by countries when they came to us for financing. And so with that, let me shift a little bit to give you a sense of what we were seeing on the country side and what our member countries were experiencing. I mean, I think it's fair to say that low-income countries, low-income countries really, caught between a proverbial rock and a hard place. The urgency of the situation placed them in such a challenging position because they were negotiating pricing in the context of reduced supply, very limited and restricted supply, but then also needing to consider how they would allocate and negotiate liability risk with manufacturers. So needless to say, liability and risk management negotiations generally were complex at the height of the pandemic. Countries were faced with two sort of big issues, really. The first is the fact that they had different requirements on liability and indemnification provisions through different purchasing mechanisms. So if they were purchasing through aggregating facilities like COVAX or AVAC, there were particular requirements under those frameworks. Yet on bilateral purchases itself, there were also different requirements for manufacturers, and that too, as between manufacturers, there were different requirements. So what you ended up with if you were country A is multiple potentially different requirements that you have to meet within a very short time frame. So there was no consistency a lot of the time. And even when you thought that the landscape had actually settled and you had agreed something, it shifted after signing documents because there were additional due diligence that were undertaken by manufacturers, for instance, to understand how deployment would take place, etc. And that entailed additional requirements on contractual terms from manufacturers. So it was differing requirements and the shifting landscape that really proved quite a challenge in terms of negotiating liability and risk management issues. Now, how are countries reacting? There are a range of country reactions. I think it really very much depended on local legislative frameworks and capacity that was already in place. For some jurisdictions, for instance, I think we've heard other speakers mention as well, there were constitutional and legislative restrictions on offering indemnities. Some countries were able to adapt very quickly to these restrictions, adopting laws that actually provided immunity. Colombia, Philippines, Lebanon are some of the examples I'm throwing out. But then there were some others where there were additional financial restrictions that were placed, requirements under their purchase contracts, for instance, that they needed to provide a financial backstop for general liability insurance. And I think we'll come to this discussion in terms of the lack of the capacity for insurance more generally in other sections of the webinar. So we'll get a little bit more insight there. But the key takeaway from the second section that I was trying to cover in terms of observations from the World Bank as a financier and also how countries are experiencing these negotiations is that countries have to get to grip very quickly with the shifting landscape of indemnification liability issues. And ultimately, even if financing was available, these shifting landscapes, these multiple requirements and differing requirements actually did end up providing an additional barrier to engagement and delayed access to vaccines. Now, finally, I'd like to sort of come to legal preparedness. And because we've talked about unprecedented situations, both in the context of the pandemic and actually how the liability and risk management landscape evolved. But let's sort of try to learn from some of these unprecedented situations and come up with some precedents and good practice for moving forward. And here are some of the key takeaways, I think, in terms of things that we could build on for the next pandemic and prepare for. Robust systems for risk management and planning before an emergency. I think that's something sort of that ties into due diligence more generally. A lot of countries during the height of the pandemic had to sort of do those due diligence from scratch. But if you actually already have an understanding of your landscape to be able to handle and withstand emergencies, acute emergencies, as we have all experienced during the height of the pandemic, I think that's one way to make sure that your legal risk assessments are up to date and can be adapted very quickly for managing another pandemic. The other key piece is trying to make sure that there's some clarity, at least, whether it starts at the international level in terms of best practice, but also just trying to sort of make sure that there is clarity of what is international best practice for some of these indemnification provisions or requirements in terms of risk allocation as between manufacturer and purchaser, trying to sort of make sure that there is sufficient knowledge sharing around this aspect will help sort of build the knowledge base going forward. But part of that also is related to the third thing, which I think is the most important piece perhaps, and that's to establish strong equitable relationships between the multiple parties involved. Contractual arrangements sometimes are not flexible, and really sort of trying to make sure that we do have clear international best practices related to these contractual arrangements, related to this risk allocation process, and working that into stronger, more equitable relationships, I think is going to be key for the next, to handle the next sort of pandemic. And related to that, of course, is all the work that's going on through the action package, which is why I'm so glad that O'Neill and the US government and Argentina and everybody involved are actually sort of working on this to try to make sure that we are actually sort of having this discourse and dialogue and transparent information sharing on what are the best approaches towards liability risk management. So with that, I'll pause and say thank you again to the organizers for inviting me, and hand over to Sam. Thanks very much.
Yeah, thank you so much, Sharmila. And as Sharmila highlighted, the risks, they began really at the product development and manufacturing, but they continue through administration. And so Emanuele Sesta from the Italian Medicines Agency will now address that final sort of set of risks or close to final, the administration of the vaccines. So healthcare workers and how liability and risk management has to be prepared for in that context. So over to you, Emanuele.
Yeah, thank you, Sam. Good morning, good afternoon, or good evening to anyone. It's 2 o'clock today in Rome. My name is Emanuele Cesta. I've been working for the Italian Medicines Agency since 2005. I'm a lawyer and currently legal officer at the agency which regulates the pharmaceutical market in Italy. I preliminarily wanted to thank Shamila, Elizabeth, Anthony, and Richard for introducing so many relevant aspects with respect to the legal preparedness and the liability, which is now our subgroup within the GHSA legal preparedness action package, which are directly or indirectly connected to the issue that I'm going to introduce you with respect to the liability of doctors and healthcare workers, which is obviously not focused due to the specific core business of our subgroup on the nature of the liability itself of the with respect to doctors and healthcare personnel, or its specific application within the criminal, civil, or administrative, eventually disciplinary field, but mostly on its delimitation and limitation within the context of the health pandemics and health emergencies, with a double purpose, actually, not only to protect the healthcare workers per se, so within their personal sphere of activity, but also to the purpose of protecting and to allow the correct functioning of the health system, which they represent an essential part of. So I kindly ask Cynthia to start my slides so that maybe you can follow me better. Yeah, we can already skip the first 2. So let's start. Here is the premises and actually also the end point. The healthcare system depend on healthcare workers' participation and their commitment. So it's not only a question of liability and direct participation and feeling part of the health system, which is called to render healthcare services. So under a number of issues, a number of considerations, guaranteeing the safety and the security to the healthcare workers, doctors and healthcare workers involved in the health services rendering is part of the cornerstone of the health emergency preparedness. Now we are focusing on the legal preparedness, obviously, but in a whole sense, we must consider how and how many ways and how many different ways the healthcare workers have been involved in the rendering of health services, particularly during the public health emergencies at international level. Now we have to take make a copy to what is currently the legal framework with respect to the liability and the limitation of the liability, since there is no complete, but not only with respect to the healthcare liabilities, an absence of the legal clarity and some ambiguity with regard to the specific indemnity areas in which they are called to operate. Let's consider as a preliminary point that whenever the liability limitation is under the spot, there is always not immediate or some critical, some difficult social acceptance whenever we deal with the consideration of a possible limitation of liability, especially because we are dealing with respect to the rendering of healthcare services. When we deal with health protection, so with one of the basic fundamental rights, which is recognized in international level by our constitutions, by the international agreements. So whenever we discuss about the possibility that those who are called, those that are committed to guarantee your safety, to provide health assistance, may be asking for their own protection, or for at least knowing perfectly the laws enforced, the laws implemented, or maybe asking for the implementation of ad hoc provisions that may guarantee their own protection and not to be involved in what has been called the liability pandemic during this period, is actually one of the most urgent communications, one of the urgent discussions that we have to carry out. And that is why we also have to deal with not only legal perspective, but also ethical perspective, because it directly involves the health workers' commitment in rendering their services. So not only to the purpose of strengthening healthcare system preparedness, but also their response. And this requires the adoption of binding regulations to guarantee a minimum legal protection for healthcare workers, especially at time of crisis. Next, please. So obviously, this is with respect to the interest, to the in advantage in favor of not only healthcare workers, of patients and citizens, so obviously, but also the healthcare facilities for which they work, in which these healthcare services are rendered. It also involves a number of local considerations with respect to the consequences in the healthcare facilities in which the services are provided. But we are always dealing in terms of safety and security, which is a mutual necessity both for healthcare workers and patients. Next, please. Now let's start. Whenever we deal with the legal preparedness, we consider the international health regulations as our, let's say, mutual terms of reference, a starting point and a Bible, we could say. So focusing not necessarily on the first of the legislation and policy core capacity number one, we may find another point of reference in the surveillance core capacity provided by the international health regulation, specifically with respect to the identification of the roles and responsibilities of those that are involved in the implementation of the health system from an active and passive point of view, obviously, not only knowing exactly who is involved, what's the role and direct liability, but also knowing what is the space of action, which is the specific field in which they can operate, and as far as they may be involved in eventual consequences, in aftermaths, in adverse reaction, always focusing on the environmental situation, the starting situation, which is a pandemic, so a public health emergency of international concern. So with this, even if the international health regulations provides its core capacity, we must admit that it does not specifically provide a minimal requirement on safety and legal protection for the workers. But anyhow, it addresses this concern, this safety concern, with respect to the public health emergency at each international level. Next, please. Now, we are all aware of what happened during this couple of years, and thanks God, it's doesn't seem to be still ongoing, the situation at the moment. But this is a brief list of the situation that healthcare workers and doctors had to face during the pandemic, especially during the pandemic peaks. So we had an initial approach in which there were no vaccines available. All vaccines were novel medical countermeasures have been developed, even if in quite rapid time, thanks to the rolling review procedure have been adopted. But we had a starting situation with no vaccine available. There were even scarce availability of medical scientific elements, and absolutely a very scarce knowledge of which treatment could be implemented. We also remember, you all remember, when at the beginning we started tackling the situation by using off-label medicinal products that were had been authorized for different indications. We had to wait. We had this watchful waiting expression while using simply products available to verify and to wait until the official medical countermeasures would be available. And eventually, with respect to the indications, to the good practices, to the directives or the guidelines that could be provided by the healthcare authorities and institutions, they could change from day to day. We also had to update constantly the reports that have been submitted to any kind of inquiries on investigations with respect to the current therapies adopted in course. With an insufficient number of healthcare personnel. Okay, we developed that there could also be shortages of healthcare workers. This shortage was progressively bigger by the contagions, by the fatigue, with this exhausting working shift that kept healthcare workers working for 36, 40 hours. We also had to accept the legitimate refuse to keep on working during the pandemic by part of the workforce that had to take into consideration also their own safety and that of their family, for example. All the healthcare workers who refused to undergo the vaccination, the healthcare workers were one of the first classes of workers who had to undergo necessarily the vaccination in order to keep on rendering their services, to keep on working. There was actually an inadequate turnaround of qualified, of trained healthcare personnel, because in order to replace or temporarily substitute those who could not keep on working, emergency urgent recruitment procedures were started, and a number of very new personnel with scarce, limited or basic experience were put in place. And actually, we are also registering, at least in our country, my country, a number of newly employed personnel who simply refused to keep on working once the pandemic has been completed, since the working conditions proved not to be so adequate, and so allowing the necessity to proceed with additional recruitment procedures. Next, please. We had objectively, it was under our eyes, inadequate capacity of health facilities. The intensive care units were constantly filled up. There were no additional hospital wards, and this not only prevented the healthcare structures to render the assistance and the healthcare services, but only to the detriment of existing patients, and delaying treatments of all the patients for their severe disease pre-existing to the COVID. a global unsafety of the working environment, which inevitably included also the condition for healthcare workers to give up, to suspend their working conditions. Already existing threats and burnout sources, for example, the constant, another element that turned out and usually arises whenever we are in the peaks of a specific health emergencies and exposure to violence and harassment. Discards and symptoms, obviously, because there were actually at that time limited resources which could not be invested in rewarding the healthcare personnel. Some were exhausted by this immediate obligation to vaccination, to the very critical conditions of work. So, next one, please. All these elements were eventually surrounded by an additional point of pressure on healthcare workers. So the famous tragic choices, this is pressure that we started to know with respect to the tragic decision that had to be adopted by those doctors, by those healthcare personnel in cases in which they had to establish which patient to treat before another, or eventually which to treat and which to be excluded by the treatment due to the limited availability of beds and places in healthcare. So from this point of view, that specific tragic decision had to be taken, let's repeat, on the limited knowledge, on the limited resources available in terms of countermeasures, in terms of indications of good practices, and so on. And also with a limited legal preparedness due to the absence of implementing course of specific provisions that could protect doctors and healthcare workers in adopting this decision to the detriment of the patient. At that time, still we were reasoning on the existence of what could constitute a reasonable and prudent standard of care during the crisis. Next one. In a sense, this necessity, this need for legal protection has been felt at international level within any possible framework during the public health emergencies. I made this example with respect to the US situation in March 2020. The American Academy of Emergency Medicine called for the federal government to provide immunity from malpractice litigation from medical care that would occur until the nationwide emergency period remained in effect. Now, with respect to the Decision Act in application of the Public Readiness and Emergency Readiness, I would invite you to listen to the presentation that Ms. Susan Sherman of the Department of Health and Human Services will provide you in due course, which will provide you very much additional information with respect to the PrEP Act. Next one. Another issue, another element surrounding this consideration. We all know with respect to these specific field of action, the expression defensive medicine, which is the phenomenon that occurs when the doctors have to take decision basing more on the possible consequences from a judicial point of view in terms of claims, in terms of possible liability claims, than considering the actual effective needs of the patient. It may be active or passive. It may lead to prescribing too many or not necessary exams and analysis and specific investigations on the conditions before taking a decision, or simply passive, not taking any decision with respect to the patient in order to avoid or limit the risks of being involved in a specific claim and litigation. These phenomena, which already existed, okay, and developed by the end of the 80s and the end of the former century, had an additional rise during the pandemic period, since at the beginning, the very beginning, we register a number of claims against the healthcare workers and doctors when the first adverse reaction to the vaccines emerged with respect to those who claimed to have their right to health not specifically protected, not implemented by their own country. In some countries, it was necessary eventually to request an intervention by the councils of the bar associations to suspend, to limit the actions intended or promoted against healthcare workers, not to discourage them and to actually put an hinder to the constant rendering of the health services. Next one. Now, these are the two directions in which the legislation in terms of the jure condito and the jure condendo, that is to say, on the existing laws and the new provisions to be implemented, took their direction. So given this very heavy pandemic conditions caused by this healthcare surge, the debate focused on how to intervene to the general moral responsibility, and this turned these two possible outcomes: the adoption of the shield rules as a general sense to establish that so-called liability lockdown as a temporary but total shield to protect their responsibility.
Emanuele, this is terrific. I do want to make sure that we get to some of the questions. Can we maybe do 1 more minute and then go to the Q&A for this segment?
Yeah.
Perfect.
Okay. Okay, the first one, Dr. Zia, what are your thoughts around compensation for instance-related injury or death in pandemic, state COVID pandemic? At what point is healthcare worker considered to have been injured from a SAH and not due to community transmission, or this affecting indemnity and compensation? Okay, let's consider my personal thoughts. It is yeah. Okay, regime regulation when taking over medical treatment regimes. Now that's exactly what I'm trying to expose. There are severe conditions, it's an objective point of view, in which the healthcare workers were forced to operate. In terms of possible liability, let's consider, for example, that we have at international level instruments to indemnify patients who suffered consequences by the vaccination. With respect to the consequences by the contagion, from being involved in the contagion, we're not been informed or were not aware of specific claims by healthcare personnel involved in the COVID disease. Specific consideration, it's an environment in which healthcare workers are called to operate, and there are specific insurances with respect to the risks coming from the difficult or risky working conditions, but these are usually provided by the healthcare structure in which they are called to work. Let me get back to the question.
Emmanuel, so I think that's a good idea, because that first question is for you in the Q&A. I just want to very briefly introduce my colleague Ana Ayala at the Office of Global Affairs at U.S. Department of Health and Human Services, and in many ways it's just really the main engine behind the legal preparedness effort under GHSA. So really, it's a delight to introduce Ana to this conversation. I'll let her take over the Q&A.
Okay.
Well, thank you very much, Sam. Thank you for that very kind introduction, and also to all the speakers that have spoken thus far in the event. I know that there were a couple of questions that did come in. Thank you, Emanuele, for addressing the first one. for this question and answer session. There was one that did come in, and thank you, Dick Wilder, for addressing the question, but and Sam. One of the the questions that did come in about the IHR, and then something to just kind of expand on as well, right, is who will provide protection for the country IHR focal person if the local legal regulations recommend not providing any organization with health information and data. That has been addressed, like I said, by Dick Wilder and Sam Halaby here already. And if just I may add really quickly to that one, is that the IHR do require that countries, provide health information on individuals. However, it does pay, it does give, let's say, deference to national laws, where there are limitations as to how much, obviously, country can share in terms of personal information that for contact tracing purposes. That is something that national focal points definitely have to kind of be careful about, for sure. But it does. It does, as an international instrument, it does pay deference to what a country may have in its own laws in terms of limitations. But there is another question. If we could, let's see, are legal instruments taking over medical treatment regimes? I would maybe ask the person who wrote the question to maybe clarify a little bit more, unless one of our speakers are able to answer that question. So one of the things that I guess when we're talking about what legal instruments can do, right, when we're sort of nationally at the national level, if that is sort of what we're discussing here, is really kind of provide the protections, right, that countries can have in terms of addressing a lot of the issues that have been already exposed here in through the presentations. As you've seen, liability is a pretty complex issue. So just in terms of and it's kind of related to what we just said about the IHR as an international instrument, and also what and that interplay with domestic legal instruments, that when we're talking about legal preparedness, countries can have sort of that ability, if we're thinking ahead, if we're really thinking about what is it that we need during a response, what are the different needs that we have as countries, right, that can help address some of these more complex and even sometimes contradictory situations, to the extent possible before a health emergency takes place. And there's another question that just came in. Okay, so the indemnification that some companies require went beyond medical injuries to also property injuries, including intellectual property infringement. What is Anthony's and Dick's perspective on the balance to be struck here? Anthony or Dick, would you be able to answer that question?
Maybe I'll start. Maybe Dick may want to add some more. It's a bit difficult to answer the question in the abstract without seeing specific language. But when I was negotiating the indemnification agreement with manufacturers, I was working at Gavi Alliance at the time, and I was negotiating with about 12 manufacturers at the same time, and I insisted on excluding any provisions around sort of intellectual property infringement because that was not related to the issues that we laid out in terms of why liability is an issue for the manufacturer. We had discussions very early on with IFPMA in terms of what are the issues that they are trying to overcome. And it was about the speed and scale. As a number of speakers have said, it was about the speed and scale at which the vaccines were being made available, and the issues that this presented to them in terms of not having enough safety data and concerns around injury cases, personal injury cases. So intellectual property infringement didn't actually address that. And it felt like when manufacturers were trying to do that, they were trying to sneak something in and try to gain an edge that that they otherwise wouldn't have been able to gain. So that was my perspective.
Yeah, let me just say real quickly, Zane, appreciate the question. I think Anthony answered it well. I would add one thing. You know, I think it's inappropriate in my view to add indemnification for intellectual property infringement. You know, in the cases that we're talking about here, you know, you're dealing with a separate issue beyond, you know, the potential injury to patients that are receiving the vaccines, and so that's a matter as between, you know, the company and the individual. And you know, infringement is, you know, might be an infringement action brought by another company against the company that's manufacturing the vaccine that's being distributed, which again is a separate issue. It's a separate set of actors that are involved, and so it wouldn't be appropriate to include in the type of indemnifications that Anthony indicated that he had developed for Gavi, and I think there are integral to the success of the ACT Accelerator. Thanks.
Thank you both so much for answering the question. We have one more that we'll discuss here, or not discuss, but address. Thank you for the PowerPoint presentation. It was more useful than just talking heads. Is there available some publication to reference the speakers? So what I would encourage, I guess, everyone here is to actually reach out to our executive secretariat for the Legal Preparedness Action Package, Kat Ginsberg, who can put in the chat the email address, so that if you are interested in sort of some resources that we can share with you on these issues, we would be more than happy to do so. So Kat, we'll mention this at the end of the event as well, but it's just in terms of getting in touch with us, and also you know, just generally following our work. That's how we can provide some publications that might be of interest. So I believe that's the end of the questions, and I will turn it back to you, Sam, for the next session.
Yeah, thank you so much. So there are some really insightful and important interviews. So thank you so much to the sort of first half segment speakers. But we're also delighted to be able to welcome a panel now with the sort of, you know, countries' experiences with these issues. So from Iraq, from Argentina, from Thailand, and from Guyana. So really a good representation of experiences across the world. So we'll listen to them for about 5 minutes each, and then we'll have a Q&A, sort of getting more into the details of their experiences. So we'll begin with Dr. Faraz Jabbar al-Moussawi from Iraq. So Dr. Jabbar, can I turn it to you?
Thank you so much. Good morning, good afternoon, good evening for everyone. This is Dr. Faraz Jabbar from Iraq. I'm in charge of National Immunization Program, and also lead the deployment of COVID-19 vaccine in the country. I'm so glad for your invitation in this valuable meeting. And to be honest, the legal perspective is not our specifications, but I will try to explain our experienced during this pandemic. Actually, in Iraq, there is, first of all, Iraq is one of the Middle East countries and has a total population around 42 million. Actually, Iraq is suffering so many challenges and competing challenges during the last 20 years, and the most serious one was the ISIL invasion, which has invaded more than 50% of Iraqi land. And by the end of this is in 2014, and by the end of 2017, we liberated most of the Iraqi areas from this terrorist invasion. During the COVID-19 eras, the good news in Iraq, there is a public health law, which is issued since 1981. But actually, when we are facing so many challenges during pandemic, we saw that this law is not responsible for all our issues that are facing at that time, and as a result of that, Iraqi government developed or established a higher Supreme Committee to deal with such legal things regarding the emergency law, regarding the lockdown, for example, care for so many areas need to be treated by this higher Supreme Committee. This committee actually was a multidisciplinary teams, and there is an expert from the academia, which was the advisory for this committee. And through this committee, we are issuing many legislations and instruction delivered to all government. At the peripheral, also there is a committee to deal with all the legislation and instruction issued by the Supreme Committee. What we are facing when we are dealing with the companies to providing the COVID-19 vaccine, which was the liability issue, liability and indemnity. And to be honest, from my humble experience in immunization, before that I don't deal with such terms regarding liability. So we are facing a big problem for how to secure these precious COVID-19 vaccine doses from the manufacturer, and we don't have such very helpful law to have these doses. At that time, by the action of the Supreme Committee, we doing a hard effort from the Parliament to making such law available according to the global need and responsive to all the needs by the manufacturer, and we developed such law in a time of about 45 days. We publish such law in the website and in the official channels, and after that we are receiving we are contracting and completing contracting with the vaccine manufacturer. From my perspective regarding the liability, I think the liability not from I think there is another phase for liability, which we are facing right now, which is the liability for the wasted doses as a result of expiry dose. So the whole health system, all the stakeholder from different levels, from central or national level to the service provider level, right now is facing so many inspections and maybe some of them were blamed regarding the wastage doses at that facilities. As a result, as you know, at the start of 2022, we are facing a drop down in the vaccine consumption by the community, and we are doing a lot regarding this communication, community engagement, and using other different channels, using legislations for making the vaccine more applicable and more acceptable by our community. But we are facing a drop down in the utilization of the vaccine, and we are wasted many doses, actually around 1 million doses. And right now we are facing an inspection by legal agencies from governmental side, how to why these wastage rates happen, and we are still in deep negotiation for them. So I think in any future legal initiation or development of a program should be treated both sides, from community level and from the health worker or health official levels regarding this issue. This is from my side. Thank you very much for your invitation.
Thank you very much. I'll now turn to Dr. Salapak Hinjoy from the Office of International Cooperation, Department of Disease Control at the Ministry of Public Health of Thailand. Dr. Hinjoy, thank you. Dr. Hinjoy, we can't yet hear you. Yes, I think so.
Okay, good. Okay, presenter are showing my slide presentation. Okay, thank you. And thank you very much for this opportunity to share countries' perspective on lessons learned on liability and preparedness during the public health emergencies. First of all, I would like to thank Dr. Sopon M. Sirithawan, Deputy Director General of the Department of Disease Control, Ministry of Public Health, Thailand, for providing information on the actual practice in each phase of the vaccination administration in Thailand. And today, we also have the Director of the Division of Legal Affairs at the Department of Disease Control who joined this webinar as well. Next slide, please. On the left, the first batch of vaccines came into Thailand in February 2021. The first priority group to receive a vaccine were the frontline healthcare workers. It's very interesting that Thailand has not just provided the COVID-19 vaccine to the Thai people. American health volunteers were the priority group of people to receive vaccines. Even in a period of the limited vaccine supply, all citizens living in Thailand and most migrant workers receive the vaccine free of charge. The Thai government has allocated the financial management for the procurement of COVID-19 vaccines in accordance with the recommendations of the National Communicable Disease Committee as designated in the Communicable Disease Act. The Department of Disease Control has been authorized by the government to sign the COVID-19 vaccine procurement contract with the vaccine manufacturers and to manage the vaccine supply. As you know, based on the contract, vaccine manufacturers were not responsible for financial indemnification. Therefore, the government decided to take liability for people who have been vaccinated. Next slide, please. How we were able to take liability. In Thailand, the National Health Security Office was assigned as a financing agency and to pay for vaccination service at 40 baht or $1 per dose to the vaccination sites. In addition, the National Health Security Office provides financial compensation to people vaccinated who have had any adverse events after the COVID-19 vaccination. We call no-fault compensation for COVID-19 vaccination. That is a Thai government policy. It was intended to increase our public confidence in COVID-19 vaccines and thereafter to minimize vaccine hesitancy. As a result, over 100 million doses have been administered to the people in Thailand between the February and October and December 2021, as shown in the graph. Therefore, 82% of the population living in Thailand receive at least one dose of the COVID-19 vaccine, with 143 million injecting doses at the end of September this year. Next slide, please. The National Health Security Office has implemented the no-fault compensation policy, including the issuing of the compensation eligibility guidelines, standard criteria, and the payment system. From the surveillance of adverse events, there were various signs and symptoms ranging from mild to severe consequence. As a result, our compensation rates varies depending on the severity of the adverse. Up to 100,000 baht is for the people having the persistent injury or illnesses. Not more than 240,000 baht for loss of the body parts or the disability, and up to 400 baht for death or permanent disabilities. By the end of 2021, over 5,500 complaints were accepted, and the National Health Security Office paid a total of 1 billion baht in compensation for these cases. Next slide, please. What have we learned? So that we can prepare for the next public health emergency. This is a challenging issue for the Thai government. If the next emerging infectious disease is just around the corner, supporting that is happen maybe in the next year or in the next months, our government still cannot fully function to produce vaccine for the mass product. We can, I think everyone can guess that in the private vaccine manufacturer still continues to maintain there is no financial indemnification. We have already recognized that the no-fault compensation policy of our foreign adverse events following the vaccination has been proven an effective measure for a mass vaccination program for a short period of time. The Thai government will implement this policy in a timely manner when compared to the time frame that what we have done for the COVID-19. And that time, we have to implement the COVID-19 vaccine before launching about the no-fault compensation policy. That means it's quite a hectic situation because the people very concerned about any adverse event, if that occur, how they can get the compensation. So if for the next public health emergency, we know how we can deal, and we still stand using the no-fault compensation policy. Furthermore, in the Thai government, we learned that mobilizing additional resources to achieve the goal of the mass vaccination under the no-fault compensation policy is a challenge. So universal health preparedness in a multi-sectoral approach beyond the health sector, we have to include the Ministry of Finance or in the other sector to join, is a key factor to the success of the program. Finally, risk communications aims at making the public understand a compensation process a timely response to the public concerns can make people trustworthy to compile the prevention program launched by the government on the national scale. This is what are the policy that in Thailand have implemented and what the lesson that we learned. Thank you.
Thank you so much, Dr. Hinjoy. We'll now turn to Carla Moretti from the Ministry of Health of Argentina. Is Dr. Moretti with us? Or available?
Sam, I think she is.
Okay.
It just, let me.
Oh yeah. Welcome, Dr. Moretti. Can you hear us? We're not hearing you yet. You've come off mute. Dr. Moretti, I think we're going to go to Dr. Ramsamy, and then we'll come back to you. Okay. It's a delight to welcome Dr. Leslie Ramsamy from Guyana to speak about Guyana's experience in the vaccine procurement process. And I understand, Dr. Ramsamy, you'll address the broader statutory framework that goes back even further than just COVID-19. So welcome.
Thank you very much. Colleagues all, it's a pleasure to participate in this webinar. I believe that it would be an absolute fantastic idea for the groups that are here, including the O'Neill Institute for Global Health, for Global Law, the International Senior Lawyers Project, etc., to contextualize the country's experiences, utilizing all of those issues that the presenters today brought up. And in fact, our experience in Guyana, I think for all of us, the politicization of public health emergencies is not new, but the politicization of a public health emergency with COVID-19 was perhaps the most visible, the most intense that we have seen overall. And it affected us at the country level because citizens, at least for Guyana and the Caribbean, have access to the media now. They could see the news, they could see Al Jazeera, they could see CNN, they could see MSNBC, BBC. They hear the news, they see what is playing out, and therefore the response of citizens to the actions that public health take at the local level is hugely informed by what is taking place in other countries. I wanted to put that up front because Guyana's experience is based on that. The issues that we all face and the countermeasures, public health countermeasures that we took were not new at all. They were being implemented under new circumstances, with new perspective, with a more engaged public. And therefore curfews that were implemented. Guyana was one of those countries that implemented a curfew early. Our first case was detected in March of 2020. And subsequently, almost immediately, there were national curfews. These curfews impacted on people's livelihood, but these curfews were not implemented, taking into consideration the difficulties it caused people and the fairness of implementing them through police officers and so, because there are also essential activities. I was about to say essential workers, but essential activities. People in Guyana do not store large amounts of food, for example. Many people don't have the ability to store large amount of food. So curfews were implemented in a context that created difficulties. The same thing with quarantine. Quarantine is not new in Guyana. Leprosy in the old days caused people to be quarantined, most of whom never returned home. TB in the early days, in the 1920s, 1930s, people tell stories, their grandparents, etc., that never came back home. But in this case, we quarantine people without addressing the fundamental human rights, and there was not a human rights based approach to quarantine. People didn't know where their relatives were. There were no communication with families, either directly from the Ministry of Health or of the ability of families to communicate now that you have cell phones, etc. These are some of the difficulties with some of the countermeasures we introduced. It'll be interesting to see how we address them. The vaccination. Vaccination in Guyana is not a new thing. We've had vaccination, and Guyana's children receive 18 antigens. We are among the world's best performers, between 98 and 100% coverage for children vaccination. So vaccination for public health purposes is something our people are used to. But there emerged a vaccine hesitancy that impacted on our ability. And so whilst the initial struggle was, could we get access to vaccine? Once we did get access, the uptake of vaccination was impacted. And for us in Guyana, that was an entirely new experience. But in part, it came from the experience of the United States and other countries, because people were watching. And why a public that is so used to and accepting vaccination for decades suddenly became hesitant. And how could our public health laws help? Because the churches became involved. The churches start preaching anti-vaccine messages. How do we intervene? So those were parts of the struggle. But the access to vaccine and medicine became an issue. The issues that was raised here with stringent regulatory authorities, etc. Most of our medicine and virtually all our vaccines before COVID-19 come from India. But once COVID came and the discussions that were occurring around it at a global level, ordinary citizens for the first time became aware of some of these issues and began to question. So the AstraZeneca vaccine, which was our first vaccine, our batch came from India, not from the UK. And the question was, is Guyana settling for unacceptable quality? In addition, because we couldn't get enough AstraZeneca and because we couldn't get any Pfizer for that matter, or Moderna or Johnson & Johnson, we then considered and implemented a vaccination program that included Sinovac from China, that included Sputnik from Russia, because on the one hand, our people were demanding vaccine, then there was this hesitancy on top of that, and then the question of why are we introducing vaccines that are not from the developed countries, such as UK and Europe and North America. So these raise a number of questions. On the vaccine mandatory regime, so we introduced, for example, that all health workers must be vaccinated. Emmanuel raised some of the issues here. We are under normal circumstances short of health workers. When health workers refused to take the vaccine, what did you do? There was the issue of introducing testing. When we didn't have enough testing available in the initial stages, when only PCR was accepted as a acceptable standard. So surgeons wanted to test patients before they did surgeries, as an example. People had to be tested before they get into certain clinical circumstances. Our laws were ill-prepared to address that. And then there were the issue of waste management. As you know, that became a critical issue. Most developing countries are still contending on the legal framework for waste management from a hospital setting. These were not things that Guyana, like many other countries, had catered for and had to deal with in previous. Although HIV had introduced many of these things. But HIV, whilst it brought these up, were limited to us, to the public health practitioners and so on. And while citizens became involved in advocacy and so on, many technical issues were not part of the discussion. It's during COVID-19 that these things became part of the discussion. So all the countermeasures had a governmental legal framework issue that we had to address. It is in that context that we are reforming our laws. We are grateful that PAHO WHO, we are grateful that the International Senior Lawyers Project, ISLP, have been working with us. And that's the reason for our Mental Health Act, a new act that is now a couple months old in Guyana. Because things like curfew, things like quarantine, they have certain socio-economic consequences. The psychosocial, psychiatric, mental health needs of people were never considered in our quarantine public health laws. They were draconian. They never considered that there could be consequences of these things. Our laws are trying to take that into consideration. We have no liability, no fault compensation rules. Those that were brought up on the regulatory things, whilst we do have some, the international health regulation, the international property rights, intellectual property rights regime, all serve to limit the interventions that could have been introduced by countries. So our problem was dealing with some of these. And one last issue, informatics, social media informatics will have to be dealt with at the global and national level. Initially, the whole issue of hydroxychloroquine as a treatment, ivermectin as a treatment, the ability of non-public health people to talk about cures and interventions for COVID really, really impacted on what the public health system could do. So in the short few minutes that I have for this, I just wanted to put on the table the issues. I couldn't go through the details of our implementation and the difficulties that these caused, but I would be willing to engage in more sturdier discussions on these issues and how the legal framework has to be reformed as a pandemic preparedness imperative. Thank you.
Yeah, and I believe we'll have an opportunity to do so in the question and answer. So I believe that Dr. Moretti can now connect. So it's a delight to welcome her in her remarks.
Thank you. Can you hear me now? Great, thank you. So you can share the PPT. Yes, great. Thank you. Hello, everyone. It's a pleasure to me to join all of you in these sessions to exchange our views and experience on legal preparedness and liability risk management. I would like to start by sharing Argentina's vision on this important topic. You will find in this slide the concept that our country has expressed in every international and regional forum, like WHO, G20, Mercosur, and CELAC, and how the purchase of COVID vaccines was addressed in Argentina. Next slide, please. During a global health crisis such as the COVID pandemic, our countries have actively advocated for medicine, treatment, and vaccines to be considered as a global public good. We understand that the multilateral cooperation mechanism has a key role in ensuring equitable access to vaccine, treatments, and diagnosis to all countries, especially in a context when many countries face financial constraints which limit their purchase capacity. We have supported initiatives regarding equitable access to vaccines and other health technology, such as the ACT-8, the COVAX, the CTAP, which we understand are examples of solidarity and multilateral cooperation. In this sense, the establishment of mechanisms of multilateral cooperation in such short time was a great achievement by the international system, we understand. As most of countries, Argentina has also negotiated and signed bilateral agreements with different pharmaceutical companies. Next slide, please. In this second slide, I would like to mention some of the challenges we face as a middle-income country, and especially regarding equity, and more specifically, equitable access to COVID-19 vaccines. In this first place, I would like to mention geopolitical tension. It became quickly clear that in the absence of deepened global health cooperations made managing the pandemic more difficult. National responses of many high-income countries have challenged a coordinated response and equitable access to critical supplies, especially in terms of export constraints. Secondly, regarding the agreement of purchase, the lack of transparency in the negotiations regarding the supplies purchase condition and contractual liability and indemnity terms and conditions were unprecedented demand from the industry. Another challenge was the lack of forceability of many agreements and had not delivery scheduled, and therefore lack of doses allocations to countries. Finally, two years later, now, we could evidence the disparities in the prices of the doses among countries, to the detriment of low and middle income countries. Next slide, please. Now, in this slide, I will talk about what aspect in terms of regulatory and liability of the many negotiation process we were challenging for us and some of the consequences. As some of you may know, within the multilateral cooperation mechanism, such as COVAX, the copies of bilateral agreements on contracts were not received on time. Not having this contract available in a timely manner means that we have to deal with a great level of uncertainty. We understand that this is not in line with good faith and cooperation principles expected from those kind of process. Argentina obtained a legislative clearance from Congress to comply with the extraordinary purchase condition of some providers. For example, extension of jurisdiction, waiver of sovereign immunity, confidentiality, upfront payment, and other unprecedented exceptional clauses, such as a typically liability and indemnity condition. Next slide, please. It's important to point out that Argentina, at the beginning of the pandemic, did not have an adequate legal mechanism to sign this agreement. Strong and fast political leadership was needed to obtain the necessary political consent in Congress to sanction a new legislative that enabled us access to the COVID vaccines. The new law empowered the Ministry of Health to sign commercial and contractual proposals in accordance with what is requested by the laboratory that produced the vaccines. Next slide, please. Despite of all the efforts, some negotiations with the pharmaceutical companies were handled by the issues related to indemnity conditions and recognition of losses. Our new law allowed liability and immunization, but not negligence. This represents a big issue for us, and we have to start a new process to modify the national vaccines law in order to update the legal framework and unblock the negotiations through a national exceptional decree. Among the issues that were modified, we can mention the deletion of the negligence clause that was in the original law and that was objected by the laboratories, the creation of a reparation fund for those injured by the vaccines, and the maintenance of confidentiality clauses. To sum up, I would like to say that the extraordinary demands of the laboratories constitute an obstacle to the deployment of our national vaccination campaign. At the same time, they generate a crisis in public health opinion for the invasion of fake news, and that constitutes an erode vaccine confidence. Next slide, please. After all is said, we can conclude that the vaccines purchase negotiations were very complex and took a long time to achieve the step to the effective application of the vaccines, the negotiation of the contract, the reception of the vaccine, customs clearance, distribution, and finally the application. These aspects are the key and can jeopardize the response capacity, especially during a pandemic or public health emergency when immediate action is required. The adequacy of the regulatory framework also generates tensions between the political powers, since negotiation in Congress take time and results are often obtained not as quickly as we need. Finally, although Argentina has developed a new legal framework to comply with industry requested, we are facing a new challenge now regarding the monkeypox vaccine, as our legal framework was created in response to the COVID-19 scenario. And for example, the law doesn't contemplate the purchase of non-registration vaccines when our country don't declare an emergency. The next slide, please. Finally, I would like to conclude this presentation with some lessons learned and what we advocate for in terms of what are appropriate and fair conditions to prevent us from repeating. Argentina is convinced of the opportunity to develop its structures and strong committees in order to develop international tools that ensure equitable access to strategic supplies for low and middle-income countries in future health emergency. Multilateral cooperation mechanisms such as COVAX should guarantee the transparency of the agreements between pharmaceutical industries and countries and forecast of any delivery schedule. Third, the full implementation of the principle of equity, not just in access, but in distribution of medicine, treatment, vaccine, and other low and income countries in governance and decision process of the multilateral mechanism for purchase vaccines. It's important to demand greater transparency in the agreement in order to achieve fair and just terms and conditions in purchase agreements. We find it very important to achieve a regional pooling of demand, and in this sense, it's crucial the role of PAHO in our region. Finally, compliance with principles of international solidarity and cooperation. I stop here. Thank you for listening, Back to you, Sam.
Thank you so much, Dr. Moretti. We'll now turn to the Q&A, but just briefly, I want to invite Anna to discuss for a moment the legal mapping work that the Legal Preparedness Action Package has been undertaking, because it's so relevant to what our panelists have described in terms of these interlocking sort of laws and regulations that needed to be addressed. So Anna, over to you.
Thank you, Sam. No, this is just sort of to mention for those that want to sort of track what we're doing as a Legal Preparedness Action Package, especially considering some of the work that has gone into improve the legal instruments technical area within the new version of the Joint External Evaluation to help countries become more legally prepared. And so the Legal Preparedness Action Package is working on developing a legal framework guide for legal preparedness that will hopefully help countries kind of understand all the different ways, including issues related to medical countermeasures and taking these, liability as one of the key areas, obviously, where can help support countries in their assessment of whatever legislation and other legal instruments they may have or not have, right? So it's a tool that we hopefully that will hopefully be very helpful for countries because just so much of what our speakers have said throughout the whole entire webinar point to this, need to kind of fill those gaps, right? Or either developing new legal instruments or by modifying them where there is needed. So, follow us. That is something, for countries who are interested, definitely let us know. And we'd be happy to continue the conversation on that particular project. Thank you, Sam.
You bet. And so our first question addresses something that Dr. Jabbar raised, and this is the idea of health service providers being personally liable where expired medicines or vaccines were used. And Hanan's question is this really an issue in other countries, and how should it be approached? So we have, I think Emanuele sort of addressed this somewhat in his talk. Liz addressed it to some extent in her talk. So I guess I would invite, probably start there. Emanuele, I don't know if you want to answer that question.
Well, actually, if we move along the concepts of the legal preparedness, it being better to consider from a legal perspective, and I was asking if you could allow me to conclude the final slides to present the three final options that are offered by the provisions adopted with respect to the limitation of the liability. So that maybe this may provide a potential reply to this question.
Kat, is it possible to pull up that slide?
The last slide, the one beginning with the shield, the legal shield. Maybe this could represent also a potential reply to one of the questions that have been formulated in the chat box, the one by Mr. Obuku. Yes, the following one. Yes, starting from here, we was just speaking about the shield rules, or as an opposition, as an alternative, the application of specific exception to existing schemes. So recalling the category of the force majeure, the state of necessity of the fulfillment of a duty. These are with respect to the single obligations that may be called as exceptions to the specific to a specific act, or maybe to a failure to act. So to an omission. This may represent the shield. Following one.
Next slide, please.
Next slide. So very briefly, the The first option would be the legal indemnity completely to emergency responders. So an exemption from the duty or from the liability. So this excluding a number of serious number of issues which could be would occur in civil law or in common law countries, but to be especially specifically provided for with respect to the criminal liability. And this represent an issue with respect to the social acceptance with this liability exclusion, or also a potential deterrent effect on the subjects who are called to act with diligence, prudence, and expertise. But this is the same consideration that we do with the no-fault indemnity mechanism. Next slide. The second option would be the liability waiver. That is to say, single, often mutual agreement that can be undergone between a doctor as a professional and a single patient, but also they represent a political ethical issue, because even in the specific informative that are provided by the associations of professional healthcare providers, they are invited to consider the professional and ethical obligations prior to implementing a waiver with respect to the single patient, because this could somehow impede or hinder the establishment of a good relationship between the healthcare provider and the patient himself. And then last slide, the third option with respect to the volunteers, or also in some specific environments, also with respect to professionals who simply cooperate without expectations of any wage or any formal reimbursement. So they have a professional skills, they have professional training, but they do not receive any payment. These are the so-called Good Samaritan laws, which have a very restricted application, also with respect to the limited assistance, that is to say that necessary immediate assistance that can be provided while waiting for the official assistance coming from the hospital and so on, and specifically the demonstration to deserve a specific shield with respect to potential liability on consideration the emergency nature of the intervention, the absence, I repeat, the absence of any compensation with respect to the service is rendering, and also obviously the absence of gross negligence, willful and irresponsible behavior, which by definition cannot ever be covered or insured with respect to a specific liability, but it's restricted to specific animal intervention. I hope the specifications may provide an answer to the
Yeah, I think yeah, absolutely. I think the short answer, Hanan, is yes. So in the United States, for sure, there are potential liabilities for administering a vaccine or other medicine that has expired. And I would ask Liz to elaborate, but we're really reaching the end of our time together. So I'll just say briefly that she says that FDA, the regulator, has the authority to extend expiration. But in addition, we have laws that are applicable to emergencies that exempt even under those circumstances. It's only really if you had a bad intent when administering the medicine or vaccine past expiration that liability would be a problem. Liz, did you want to?
If I can add one.
I don't want to belabor, get into the weeds of it, but yes, we do have laws that help us extend the expiry under certain circumstances based on data that we can look at. And then that would provide all the mechanisms for the liability protections. So we work to make sure that if we can do that, we do that.
Yeah, and then our last question is for Dr. Hinjoy. And so Dr. Hinjoy, if you're with us, the question is did the system that Thailand used for no-fault compensation did exist before COVID-19? Does it cover more than just COVID-19 if it did?
Okay. Okay, thank you question. I'm not sure this is maybe in the poor signal from my side. Can you hear me?
I can hear you, yes.
Okay, great. Okay, for the question that in the we apply, this is a no fault or compensation. This is the first time of Thailand that we apply this policy to find the COVID-19 vaccine. We have kind of like the under the Article 41 of in the Universal Health Act. That is already issued in the 2004. But when we apply this in the article, this is for like the treatment. It is for the medical treatment for the patients. But we never use this kind of in the act to in the for in the adverse events from in the vaccine. And because in the COVID-19 vaccine, it is for the emergency use only. That means for the other vaccines, we already have like it's a long process to like a FDA documented, registered, and that's meaning that the people in the quite touch within the vaccine. But the for COVID-19 vaccine is an emergency use only. That's why we imply for in the article the Universal Health Act to find the COVID-19 vaccine. This is the first time for Thailand.
Thank you very much. Hanan has a follow-up, but I'm going to go ahead and it's kind of like answer that via email and kind of put my head together with Liz and Emanuele. But we are at time, and I wanted to make sure that Carla Moretti had the opportunity to sort of sign us off.
Hi, Sam, here I am. Yes. Bueno, first of all, thank you. I would like to thank the leader of Legal Preparedness and Action Package, the effort to organize this event, especially to the Liability Working Group, and of course, to those who have participated. After having heard every speaker, it is clear that the Action Package represents a great network of academic, non-governmental organizations and country representatives that serve as a platform to continue working together for technical cooperation in legal preparedness so that the future find us better prepared for face the challenges of global health. Is it true that we are living the consequence of the COVID pandemic, which has directly impacted the health and well-being of millions through the world? Global health promotion should be a strategic health priority for national policies, which in our country is reflected on an active participation of the GHSA in the action package and in various multilateral initiatives aimed to develop and maintain IHR core capacities and ensuring its full integration into the national health system. This webinar represents an excellent opportunity for complex topics related to liability to be exposed and discussed by the wide range of experts and for countries' representatives to use these concepts to apply them to the realities and strengthen capacities. As I mentioned during my presentations, we are facing another challenge regarding monkeypox, which has already affected more than 65,000 people during the 2022. The outbreak was declared a public health emergency of global importance, and it is of utmost importance to look back and identify the lessons learned and missed opportunities so we can be better prepared. We welcome the webinar to head in October that will focus on potential solutions to managing liability and risk management as a commitment through the fair and equitable access to strategic supplies. We are very much appreciate the support and discussions that we can provide concrete action and tools for countries based on the principles of international solidarity and cooperation. Now I give her the floor to Anna in case she has a final remarks and announcement. Thank you.
Thank you very much. So it has been really a pleasure to have you all here, especially for such an important issue, and also for the very first webinar we're holding on a specific legal preparedness issue. And just on behalf of the GHSA Legal Preparedness Action Package, we want to give a big thank you to our speakers and to all here for joining us today, and hope to see you all next week for the second part of the webinar series, when we'll delve a little more on solutions and for liability risk management. And please don't forget to register. I might ask Kat or Cynthia to post the link to the registration page for the next webinar on October 12th. And we want to also encourage you to follow the action package via the LinkedIn group. You should be able to find it by just typing in the Legal Preparedness Action Package or some of those words there. And please also, yeah, you can basically get more information from us if you contact the executive secretariat. We've already posted the email address there a number of times, but maybe Kat, you can post it once again for before we sign off. Thank you.
Thank you.
Thank you. Goodbye.
Thank you.
Thank you. Bye.
Bye.
Thank
So
you.
much.
Thank you.
Bye, everybody.
Bye.